Sure.
Good morning. It is now 8:06, and I am calling this meeting to order. I'm Mayor Richard Irvin. I'm the chairperson of the Electoral Board. Also on the board is second senior alderperson Wani Garza and City Clerk Jennifer Stallings. The Illinois Election Code mandates our service to hear and pass upon objections filed against challenges against a proposed referendum in the city of Aurora. At this time, I will ask the city clerk to please call the roll.
Mayor Irvin,
Present.
Alderwoman Garza,
Present.
and City Clerk Stallings is present.
We have a quorum. All right. At this time, we are going to address the rules and procedures. I'm going to briefly turn it over to Board Attorney to explain the proposed rules of procedure.
Thank you, Mr. Mayor. The proposed rules of procedure are the standard rules of procedure that we have used.
And just for the record, go ahead and state your name.
My name is Ross Seckler. I'm the serving as the Electoral Board's attorney in this matter. The proposed rules of procedure are the standard rules of procedure that this board has been using for a few years now. They are their versions modified from rules issued from the State Officers Electoral Board used by the State Board of Elections, the Cook County Officers Electoral Board, as well as the Chicago Board of Election Commissioners that routinely hears these types of objection cases and just modified for any to be able to take place in the city of Aurora. They are standard. The reason for the rules are to have a fair and transparent proceeding, to ensure that the board and the parties all know how to file documents, what's expected of them, who can appear, and what rules of evidence or other procedures are in place in this type of proceeding before this board. And I would request that there be a motion to accept the rules of procedure as presented.
I move this Electoral Board adopt the rules of procedure as presented. Is there a motion? Is there a second?
Second.
All right. There's been a motion and a second. All in favor?
Aye.
Aye.
Aye. Motion carries.
I will have you all execute one copy, and then I'll distribute the final executed copy.
Wait, I'm signing right here?
Yeah.
There you go, Wayne. All right, now I will turn it back over to our attorney to proceed through the remainder of the agenda.
Thank you again, Mr. Chair. And again, this is Ross Seckler, serving as Electoral Board's attorney in this matter. There's one matter before this board. It's the case of Patricia Smith versus the petition for referendum requesting that an advisory question of public policy be submitted to the electors of the city of Aurora, and John Leish as principal proponent. The case has been numbered 25 AMOEB 01. Are the parties present or accounted for?
Good morning, members and Attorney Seckler, John Fogarty for the objector today.
Thank you, Mr. Fogarty, and you have filed your, or will be filing your appearance here. I acknowledge receipt of your appearance. Is there anyone here on behalf of the proponent? Is there anyone here on behalf of the proponent or John Leish? Or anyone in support of the petition for referendum? All right, seeing none. For the record, we do have a received personal service mail waiver on behalf of the proponent, Mr. Leish, executed on January 9th, 2025, that notes that he has waived formal service. He understands that he, by law, he could have been served by certified mail or by law enforcement official, but he did receive a copy of the objection as well as all of the and his petitions. at least he was the proponent of the petitions that were filed for an advisory question. He chose to be served by the office of the city clerk and received those documents, including the objector's petition filed against the petition for public question, as well as the call of this electoral board and setting this in the call and agenda that set this hearing for today, January 13th, 2025 at 8 a.m. in City Council chambers of the City of Aurora, 44 East Downer Place, second floor, Aurora, Illinois, 60505. And he acknowledges and signs that he waived service by a law enforcement official or certified or registered mail, and he acknowledged receipts of those documents. He's further executed a notice to proponents and consent by notice of consent to notice by email of objection filing that was executed, I believe, on also on January 9th by Mr. Leish, acknowledging that he accepts service of all and notice of objection filings via email. Again, those notices have been provided to him, as well as copies of these objections. I think the time being 8:12, there's no one, the objector is personally here. Mr. Leish is not. I believe there's no one else here unless, if you want to wait maybe 5 minutes, check out in the halls just to make sure.
For the record, the
Yeah.
objector is here personally as
Yes.
well and through counsel. And I think it would be fair to wait another 2 to 3 minutes till 8:15. And then we, of course, are ready to proceed.
Thank you.
At this time, we will just recess until 8:15.
And for the record, I will go in the hallway and make sure no one's standing there. Sure. We'll park back.
The record reflected is now 8:15. Council, can you proceed based on the petitioner not being present?
Yes, thank you.
I'm sorry, not the petitioner,
The proponent.
proponent.
Yes, we'll proceed. For the record, I personally looked into both hallways leading to the council chambers, and no one at all is present. No one else has come into the room, the city council chamber, since we took that brief recess. And Madam Clerk, there's been no communication from the proponent indicating that he'd be late or anything like that, is it? Or is the attorney?
No indication that he would be late or that he would be present.
Okay, thank you.
As a matter of fact, he made an indication that he would not be present. Is that correct?
He had indicated that he did not intend to appear, last conversation that I had with him as of, I believe, Friday morning.
And although, don't know if it can be taken as evidence, just so everyone is aware, he also, on his social media, made it clear that he was not going to be present and not going to challenge the objection.
Okay, thank you. It's good to know. And being not present, not indicating that he needed a continuance or something like that for some sort of good cause reason. It was because he does not ever intend to appear in this matter, I believe. At least that's my understanding, and please correct me if I'm
That's
wrong in
correct.
that understanding. So then it would be appropriate to proceed accordingly, pursuant to our rules of procedure. And Mr. Fogarty, are you ready to proceed?
I am.
Okay. So at this time, it would be appropriate for the Electoral Board to enter its exhibits, and I propose the following: that Exhibit 1 be the objector's petition, Exhibit 2 be the petitions for the referendum question, Exhibit 3 be the call of this Electoral Board, Exhibit 4 be the agenda for the initial hearing, Exhibit 5 be all proofs of service, waivers of service, and any appearances filed by the parties, and Exhibit 6 be the rules of procedure adopted by this Electoral Board. Can I please get a motion to accept the Electoral Board's exhibits into evidence?
So moved.
Second.
There's been a motion made by Clerk Stallings, seconded by Alderman Garza. All in favor?
Aye.
Motion carries.
Perfect, thank you. And Mr. Fogarty, can you please state without much argument, the general summary of the issues raised or the nature of the objection?
Of course, I'll be very brief. The proponents have offered a referendum petition seeking to place a question on the ballot at the upcoming election in the city of Aurora. We have objected to the format of the question. It is written in a way that is contrary to state law in many aspects. As well, on the face of the petition, there are too few petition signers in order to get this on the ballot at any rate. No more than 2,044 purported signatures appear on this petition, whereas the statutory minimum is at least 2,957. So it fails in that respect primarily. But we really take exceptional issue with the wording of the question and what this question seeks to get to. This question is not a serious question. This question is a sham question. This question is written as a solution seeking a problem, and it is written in such a way that it would sweep into the effect. The effect would sweep into almost anyone doing business in Aurora, almost anyone living in Aurora. By its plain language, the question would seek to limit contributions from individuals who are seeking any official action from the city of Aurora. Well, that could be anyone who is asking for a permit to build a garage, to turn on new water service, to build a fence. That could be anyone simply FOIA-ing the city of Aurora. That is asking for official action from the city of Aurora. And so what this question does is masquerade as something that is serious, but in fact, it's written in a way that is not serious at all. There are other problems with the question that we have laid out in the objector's petition. The vagueness of the manner in which it is written. But in addition, the state of Illinois already easily and well regulates contributions to anyone who is running for office. That system is transparent and it is available to everyone. And there is no need for such an overlay of supposed campaign finance rules in the city of Aurora. And in addition, I may add, this very idea was debated in this chambers and rejected. So this is nothing more than a tactic, and it's a shame when people continue to use the electoral process in a non-serious fashion. I wish the proponent were here today to try to argue any of these points, but he is not, and that tells us a lot. So we think that the law is clear here, and we would ask for this objector's petition to be granted, and that an order entered, or a decision be entered here that bars this question from appearing on the ballot in the city of Aurora. Thank you.
Thank you, Mr. Fogarty. Do you have any of the materials from either Kane, Will, or Kendall County and DuPage that show the minimum number of signatures, or?
I don't have them currently.
Okay,
with-
no problem.
I believe we can take judicial notice of the election results that are on file with each of those four agencies.
Yes. And so for the board's knowledge, the minimum number of signatures to put a referendum question on the ballot, whether for most binding in this type of sense or advisory, is 8% of the total vote cast for candidates of governor in the preceding gubernatorial election by registered voters of the municipality. That's 10 ILCS 5/28-6. The objector alleged that there were 36,951 votes cast for governor in the 2022 gubernatorial election by the voters of Aurora, and therefore that would render the statutory minimum number of signatures to be 2,957. With this, and then the allegation is that there are only a maximum possible number of signatures on the petition being 2,440, which would be under that statutory minimum. Therefore, I guess on its face, the referendum petition, even before getting into the nature of the question and whether that's a valid question, it wouldn't satisfy the basic minimum standards to appear on the ballot. So,
How do we
any
proceed?
questions? So on this, it would be my recommendation, absent any other.
Hold
Oh, sure.
Do you have any questions?
yeah.
Any questions before attorney makes a recommendation? Go ahead, Nami.
So I would recommend that we move, that the board find that the petition for referendum does not have the minimum, does not on its face have the minimum number of required signatures, and find that the proponent is in default, meaning that they didn't appear to defend it, but the rules do provide, I don't believe the objection is verified, so Mr. Fogarty did make his argument and put in the record what those arguments are. So we didn't take everything on its face in the objection, but we have the arguments now. We find that the proponent defaulted, and that based on the maximum number of signatures possible to even be on the petition versus what the statutorily required minimum is, that on its face, the petitions do not contain the required number of signatures, and therefore that the question not appear on the April 1st ballot. And we would issue notice, you would vote and issue notice to the proponent as well as the objectors regarding the determination. If the proponent somehow appeared, we would, at the next hearing, where you would be entering your final decision, the board could consider what to do with that, to allow any arguments if he does appear. But beyond that, I would recommend entering that decision and then setting a date to enter a final written decision that would encapsulate that as is required by law.
So can I have a motion to grant the petitioner/objectioner's petition to dismiss this case?
Make motion.
Second.
There's been a motion made by Alderman Wani Garza, seconded by Clerk Stallings. All in favor?
Aye.
Aye. Motion passes unanimously.
Very good. So we will need to just pick a date to come back so I can write up the decision.
Do we all need to come back, or is this something we can just have you write up decision and sign it later?
You do have to approve it in an open session.
Tell you what, why don't we do it before a city council meeting or a COW meeting, so we're already here. We can do it, how long do you need? Do you need more than 72 hours? Do you need particular time to give notice to people?
Yeah, that would be ideal in
All right.
my week's a little.
In that case, the next, tomorrow would be too quick. The next
21st.
week, the 21st, January 21st, we have a committee of the whole meeting at 5 o'clock. We could do this at 4:30.
Yes, that sounds good.
Okay.
Does that work for you, John? I mean,
Sure.
It's entry of decision on this, just in case the other side does
Of course.
appear.
Yes.
You may want to.
Yes, thank you.
Or else I would usually say.
I'm sorry,
it's-
I didn't realize, Council, is that
Yeah.
date good for you?
That's very
Okay,
good. Thank you.
Apologize for that.
So the Tuesday, the 21st. You said 4:30?
Yes.
Okay.
And based on the fact that Senior Alderman Mike Seville was not part of this particular proceeding, he will not be a part of the next one
Correct,
as well.
correct.
We will have second Senior Alderman Mike
Yes.
Garza present on that one as well.
Senior Alderman Seville was not physically available for these hearings today due to work commitments, which is a valid excuse, and therefore he was excused and recused himself for those reasons, and substitute Alderperson Wani Garza has served as second senior alderperson. That being said, with the board making those findings and granting the objector's petition and finding a default, we will need a motion to recess these hearings until Tuesday, the 21st at 4:30 p.m. for the purposes of the final entry, execution, and service of the electoral board's decision.
Is there a motion?
Motion.
Second.
Motion made by Alderman Wani Garza, second by Clerk Stallings. All in favor?
Aye.
Aye.
Motion carries.
Are there any other matters to come before this electoral board? Or any other public comment? There being none, I would ask for a motion to recess the municipal officers electoral board for the city of Aurora until January 21st, 2025 at 4:30 p.m.
Motion. Approve.
Second.
The motion is second. All in favor?
Aye.
Aye.
We stand in recess. Thank you.
All right.
Thank you.